Welcome to Self-Representing in Family Court. Your host, Tracey Bee. That's me. So, here we discuss strategies. Yes, strategies and how to use them to get the results you want in family court. If you're self-represented, pro se, pro per, or if you have an attorney and you just need to know what it takes to get through this complex family court system we have, this is the place to be. We discuss strategy. We discuss tactics. We discuss tips and tricks. We discuss techniques. We discuss secrets. We discuss it all. Whatever it takes to get you the strategy that you need, that's it. That's here. That's what we do. So sit back, take notes, and kick ass. Well, hello there. It's me, Tracey Bee, and I'm here for another episode of Self-Represented in Family Court. I am Tracey Bee, former family law attorney, mediator, ProSeLegal, and family court strategist. My specialty is working with you if you are pro se or self-represented in your divorce or custody case. And that makes this week's topic appropriate. When to or not self-represent in family court. That's what we're talking about today. Because I realize that people confuse when to handle their case on their own, if they should, how they should, and all the other things that comes along with it. So I chose this topic this week specifically because it's been coming up quite a bit lately. And as you know, I choose my topics based on real life experiences, whether it be things people ask me about, issues that come up with my clients. Actually, sometimes it is off the top of my head. I'm not going to lie. So let's get right to it. When should you or not represent yourself in family court? Well, there's a few instances where it's almost absolutely not a good idea to handle your own custody or divorce case. And I'm going to get to that. But I wanted to take a minute to say this. Self-representing is a bold move. And more people are choosing or opting to do it now. They are intentionally deciding that they're going to handle their own divorce, maybe all of it, maybe some portion of it, or their custody cases. Again, maybe all of it, maybe just some of it, on their own. 10, 15 years ago, this was not as widespread as it is now. Why? Well, one major reason is the pandemic. When the pandemic happened, the filings, divorce filings, and custody filings have soared. I mean, they skyrocketed. Why? Because people realized after being locked down for several months that they didn't like their spouse or their significant other. Or there were some people that withheld the kid and used the pandemic as an excuse to keep the child or the kids. And so divorce filings, custody filings went up. Although they went up, the resources that people had available to them didn't. So a lot of people were forced to go to court on their own. But you know what happened? Some of those people said, you know what? This isn't the worst thing. I'm getting better results taking care of things myself. Well, you know what didn't exist also 10, 15 years ago? The level, the extent of resources out there. I mean, there are resources up the wazoo. There are sources, there are people, there are groups. There's so much out there that makes it not easy, but easier to handle your case on your own. And again, when I say handle your case, you could handle just the beginning portions of it, which I recommend people do. You can decide, hey, you know what? I'm going to start this on my own, and at some point I am planning to hire an attorney. And then there's some people who say, you know what? I'm going to hire an attorney only if my case goes to trial. And then there's some people who say, I'm never going to hire an attorney unless things get that complicated, or it just looks like I'm being annihilated in family court. Then yeah. I mean, there are people who just don't have a choice, right? We know that. There are people who don't have a choice. No matter what the circumstances are, they have to go ahead and fight their battles all on their own. And I commend you too. But to those who are choosing to self-represent, this discussion is specifically for you. Because just because you could does not mean you should. Just because you could does not mean you should. You should not take it upon yourself to handle your case on your own if any one of these 6 factors I'm about to discuss with you exist, if they all exist, if some of them exist, if any one of them makes it more likely than not that you're going to lose, quote unquote lose, then yeah, you might want to revisit. By the way, I do have a quiz, an assessment that will help you figure out, determine if your case is pro se worthy, if your case is pro se appropriate. And if you want that quiz, just check the show notes. I will put the link in there. You can download the quiz. It'll give you a score. It'll help you figure out what is the best route for you based on your specific circumstances. So let's get into it. I'm going to discuss 6 factors that I can think of, that I've come up with, that really impact the outcome of your case if you are self-represented in family court. Let's start with you. Who are you? Are you capable of representing yourself? Are you capable of doing the legwork? Are you capable of exercising due diligence? Are you capable? Are you able? And when I say capable, I mean mentally, I mean emotionally, I mean from a practical standpoint. Can you handle your case on your own? What does that entail? Well, a lot of research, lots and lots of research. You have to be able to find answers on your own. Yes, you need to be able to find answers on your own, not asking somebody else. You need to be able to find answers. You can actually get answers from attorneys if you get legal consultations from them. Paid ones I prefer, because the paid ones, they're really going to actually go the extra mile in providing you some solid, sound advice. The free ones are usually just ads. It's just generic information that you can just read on the internet on your own. But so when I say research, I mean, yes, you can ask an attorney, but asking anybody else who's not an attorney, who does not have any professional experience in family law, no, doesn't count. You need to be able to find answers, going to the library, learning how to use case law research databases, Googling, learning how to navigate your court's website and understand how you find instructions and forms on there. You need to be able to do research. That's number 1. I think that is the most important thing when you're pro se. One of the most important skills that you have to master. There's others, like communicate. You have to be able to communicate. You have to be able to communicate clearly and effectively. That means when you're talking to the other party. That means when you're talking to the judge. That means when you're talking to opposing counsel. That means when you're talking to any of the family court key players. You have to be able to communicate. You cannot have angst or anxiety about speaking to people because they sit in a certain, or they serve a certain role. You cannot. You have to, if you have to modify your communication, your method of communication, so be it. But you still have to effectively communicate. Effectively communicate means you're only asking questions, you're only answering the questions that are being asked, and you're only asking questions that are relevant to the issues or the topics at hand. That's one way of defining effective communication. You also have to be organized. Yes, you have to be organized. Documenting is not enough. You have to be able to organize whatever it is you document, right? There's no need in documenting everything if you're just going to compile a boatload of information and documents and data and all that if you don't know what you're going to do with it. You have to, because you can't take it all to family court and expect the judge to sift through it and to figure out what's going on. That's not how it works. That's not how it works. So you have to be good at organization. You have to be able to organize. And I want to throw one more in for good measure, but you have to be able to problem solve. If you are not a critical thinker, there's a debate about whether or not you can learn to be a critical thinker or a better critical thinker. But if you are not good at problem solving, if you, for some reason, have an aversion to really getting down to the nitty-gritty of identifying a problem and then solving it, you're going to have issues with representing or handling your own case. And then there is the case. What type of case is it? What type of case is it? Is it an initial case for divorce or custody? Is it a modification case? Is it just a motion for contempt or enforcement? Is it an ex parte motion? Is it a post-judgment motion that you need to file? All of those things are going to, should determine whether or not you're going to do it on your own. Not everybody should walk into family court on a contempt motion, filing a contempt motion, thinking that they're going to prevail. Some people are good at it, but it depends on the issues. It depends on what you're seeking. It depends on the background of the case. It depends on your judge. It depends on the other party. It depends on the key player. It depends on the stage or the phase of your case. All of those come into play. They do. They do. How about the issues? A straightforward modification custody case might be easier to litigate than a relocation or modification relocation case, right? Yeah, because a straightforward modification custody case, you just have to prove that there's a substantial or significant change in circumstances, plus that proposed change it does meet the best interest factors for your specific jurisdiction, right? As opposed to relocation cases, there are a lot of states who don't even specify what the court is going to need for you to prove that relocation is in your child's best interest. There are some states who specifically state or indicate what that criteria are, like New Jersey. And then there's some states that there's nothing. You have to know how to find what they deem appropriate, what they deem qualified criteria to seek or dispute relocation, depending on which side you're on. And that's another thing too. If you're the petitioner or plaintiff versus the respondent or the defendant, I guess that would fall under you. That would fall under you, case type, case issues. So it's all in several factors, actually. So how about the issues of parental alienation? That's tough. That's tough. I have not seen anybody successfully prevail on a parental alienation, a moderate to significant parental alienation case per se. As a matter of fact, when people come to me and they ask me to help them, if they are unrepresented by an attorney and they're, trying to pursue, they're trying to litigate, strongly litigate a moderate to high level parental alienation case, I often suggest they hire an attorney. the sad thing is that there's no giving up or settlement in parental alienation. Most of those cases need to actually go through the litigation process, the litigation phase of trial, to, for the targeted parent to get any sort of real recourse or to make any real headway in parental alienation cases. How about false allegation cases? False allegation cases too can be really, really tricky. It can be very tricky because in instances where there's a repeated pattern of false allegations, that's a little different than an initial case, divorce case, for example, and part of the divorce cause, I guess, includes false allegations of violence or abuse or neglect or anything like that. False allegations can be very tricky and can be self-defeating if you are the accused and you intend to self-represent. The nuance about that is that in some jurisdictions, false allegation cases or domestic violence cases they have a program or they have a process by which an attorney can handle that portion of the case if it falls under the guidelines. Usually if there's a criminal element or component, a lot of times the court will assign or appoint an attorney just for that part of the case. How about in cases where there's allegations of abuse against the children or neglect against the children or sexual abuse? Again, those are really, really tricky, really, really tricky, especially if there is a substantial or significant or I don't want to say proven, because that's what's actually usually in dispute, but if there's enough support or evidence to basically make that claim valid, then it may not be as challenging. But if you're the petitioner and you're pushing for the judge or the court to address issues of abuse or neglect against the child or sexual abuse, and there is no significant evidence or there's no reports or anything that support or back up your claim, being self-represented is going to be really, really hard. It's going to be hard to accomplish what you're setting out to accomplish on your own in most cases. Again, nothing I say should be considered legal advice. I have to remind you of that. But from my experience, being pro se or handling a case where there's sexual abuse claims or DV claims or abuse claims against the child, or where the child is included, then doing that on your own can be very tricky if you're just expecting the judge to make a ruling based on your testimony. And I'm actually carving that specific scenario out because that happens a lot. I see that happen a lot where, either parent, mom or dad, will make allegations of neglect or abuse against the child in court, but they have nothing to substantiate that. Absolutely nothing. And sometimes even when they do, and they get CPS involved, and CPS decides to dismiss the case or issue a no finding or unsubstantiated claim, that makes the case in court that much more difficult. It makes it that much more of a challenge. So if you are really concerned about your child's safety, then I don't know if you want to take any chances by trying to handle the case on your own in those specific circumstances. So, which brings me to complexity of the case. If the case is, high conflict, and it's a high conflict case from day one, because some cases don't actually start out as high conflict. Some cases start out as low to mid conflict, and then they actually escalate to high conflict. And then there's some cases that, do the reverse. How would you know? Well, you would have to, at any point you can, become pro se. At any point you can decide to hire an attorney. So if your case is high conflict from the beginning and it proceeds on that high conflict track, then chances are you will need someone to help you get through the nuances of not just family court, but dealing with the opposing counsel, the opposing party, the key players, and so on. So if your case is high conflict, and some will say, hey, Tracey, aren't all parental alienation, DV, false allegations, aren't they all high conflict? Well, no. Sometimes those cases, like I said, some cases start out as being low to mid conflict and they actually escalate. Well, that happens sometimes. Especially with parental alienation, sometimes they don't start off that way. Sometimes they're just going back and forth to court and they're just, both parties or both parents are fighting over custody. But at any point, and family court is second to second, not minute to minute, it's second to second, milliseconds to millisecond. Things just change. Change in an instant. And sometimes the parties are, just proceeding through family court, with no real major hiccups along the way. And at some point, something happens with, for example, with co-parenting scenario or situation, and it causes either parent to kick it up a notch and all of a sudden become, recalcitrant and uncooperative and antagonistic, and thus making the case a high conflict case. Sometimes it's a lawyer getting involved. Sometimes when two lawyers are involved, that makes a case go from low to medium conflict to high conflict. So again, not all PA, DV, false allegation cases are high conflict cases from the start to the end. Sometimes, like I said, at any time they could, take a detour and proceed onto that high conflict track. So if that's the case for you, then again, you want to consider whether or not proceeding with your case on your own is the best. When I say proceeding with your case on your own, that is actually going to be something you base on what your overall objectives or goals are. Some people, they have every intention to resolve the case early on. When I say some people, I mean both parties sometimes agree or have an idea that they're not going to be in court for more than 6 months, and that even sometimes when it does start off as being high conflict, they may decide from the beginning or at any point that they are not going to do this anymore, and they decide to resolve the case in the best way possible. Some people just abandon the case. That's very, very few, but sometimes that does happen. So that is, you're deciding or choosing or opting to handle your case should be tailored to what you expect to accomplish by doing that. If you expect definitive, if you have, outcomes and goals that are definitive, that are specific to you, then you want to tie that into whether or not handling the case on your own is the best way to accomplish whatever it is you're setting out to accomplish. And then there's the other party. Is the other party really high conflict? Are they non-cooperative? Are they represented by an attorney? Do they have a better support system? Do they have more resources? Those are all things you'd want to consider too when you're deciding or you're choosing or you're trying to figure out if pro se or being self-represented is the best option for you. Because sometimes your case can be low to mid conflict, but you're dealing with someone else who can be really, really uncooperative or, like I said, antagonistic, and those might be triggers for you. They may, recall some stuff for you that, happened during your relationship, and it compromises your ability to think straight or to, be any of those people, have any of those characteristics or personality traits that I mentioned about your mental and your emotional and your personal. So that should not be overlooked at all. At all. And then there's the available resources and the support. Are you in a state that has a lot of resources for pro se litigants? Florida happens to be one of the states that actually, and California too, some counties in California, happens to be places where pro se resources happen to be really, really good. And then you have places like Tennessee and Mississippi where they have literally nothing. And I think it's either North Carolina or South Carolina, one of the two, have almost nothing to help pro se litigants navigate the family court process at all. I mean, they don't even have anything on their websites like most other states do. So you need to consider that. What would you do if you're in a jurisdiction where they are not? There's some jurisdictions where the judge will say they will, and you know, this, I heard this and I thought this is insane. But there's some places where the judges will tell you, you cannot come back here without an attorney. I will not hear your case. And you know what? Honestly, that's a violation of your constitutional rights, honestly. But that's a whole nother topic for another day. But if you're in a jurisdiction that way, you know, that's actually premised upon, you know, no pro se, no self-represented litigants in family court, then you might want to rethink that. You might want to rethink that. Yes, you do have the right. Absolutely. You do have the right. It is your right. But do you want to actually enforce those rights in, you know, a court where you're literally fighting for custody of your kids or financial support or division of assets? Do you want to do that? I don't know. That's for you to decide. But it is a question to ask. How about your support system? Do you have a support system? Do you have a group, or are there groups in your area like Divorce Care or First Saturday groups? Are there meetup groups that help you, support you through the process? Do you belong to a church? Are there nonprofits in your area that provide those kind of services? Do you have family and friends and coworkers who are supportive, and an employer, actually, who are supportive and understanding and will help you? Because being pro se, it's going to affect every aspect of your life, your job, your health, your mental, your emotional, your relationships. Yep, your relationships, your finances, your vacations, your hobbies. It affects every aspect of your life. And if you don't have support in almost all of those, at least some of them, then it might be more of a challenge. Because this is the thing. Choosing to self-represent or being pro se in light of these challenges might affect you and your current status or your current position or your current predicament, but it can also affect not just the overall outcome of your case as it stands right now, but it can position you in a way that's not advantageous to you for future court. Because as we all know, family court does not end until your youngest reaches the age of majority, whatever that is in your state. So even if your case is resolved in 2025 and your kids are 5 and 3, you got the next 15 years, 2040, that you might be hauled back into court, or you might be the one hauling the other party back in court. But the bottom line is that door is always going to be open. And why do I say this? Because yes, if you guessed what I was going to say, and you guessed that I was going to say that having that door open means that you need to live your life or move or maneuver in a way that you are aware of, or you are acknowledging, or you are incorporating the fact that that door is still open, then yes, you are right. That's exactly what you should be doing. So when you decide to be self-represented right now, at any stage of your current case, it's not just about you doing it right now and you're going to get it over with and, you know, you're going to be done. If you do it wrong, quote unquote wrong, or it's not pro se ready or worthy or appropriate, then you might be positioning yourself in a negative way in the future, for future family court appearances or future family court cases or, experiences later on, 5 years, 7 years, 8 years down the line. So again, you should align your decision with your overall goals, but your overall goals should be short-term and long-term. You should always have short-term and long-term goals for family court, for your family court experience. All right? So if you thought you were ready to take on your case on your own, and this episode, this discussion changed your mind, well, it might be the best thing for you. If you're unsure, then reach out to me. Actually, I'm going to put the link in the show notes. You click on that link, it will take you directly to this quiz/assessment that I created, and it will help you decide based on your score what your next move should be. The good thing is I'm here for you. Yes, I am here for you. If your case is not necessarily unworthy of being pro se, but it's not necessarily worthy of being pro se, then I'm here for you. I can help you. I can support you. I can be all the things, well, most all the things that you have a shortcoming at. If you are self-represented and your case is worthy of it and you just need that extra layer of approval or confirmation or reassurance, I'm here for you. If you are, or your case is totally not pro se worthy, not pro se ready, not pro se appropriate, then you need to work with an attorney. If you can't afford one, you need to try the legal aid offices, the law schools in your area. You need to see if there's attorneys doing pro bono. But if you have the means to hire an attorney, again, I'm here for you because I do have a service that helps people search and vet appropriate attorneys. Search and vet. Yes, I will vet the attorneys for you to see if they are a good fit. That takes quite a bit of work, but it's so helpful because you don't want to forego self-representing to only hire an attorney who's going to sabotage your case. I'm sorry I laugh, but I see it so often. Sabotage your case even more. There are some great attorneys out there, but you have to really look. You have to really do a deep dive into their background, their qualification, their experience, even their personalities. And so I do that. I and my paralegals, we actually have a process that we implement where we not only search for, but we vet any good prospects, any good matches for not just for you, but for your case, your issues, your background, as much as information as we could actually get from you. We try to use those as criteria to match you with the right attorney. So if you need me, let me know. You can feel free to reach out to me at my email, divorcecoachesq@gmail.com. You could visit my website at www.divorcesolutionist.com/contact us to set up a meeting, a 15-minute free strategy meeting, or you could just simply download my worksheets that will be in the show notes and reach out to me then if you need further assistance. So that's all I have for you today. Thank you so much for tuning in. I appreciate you all. And until next time, bye-bye. I want to thank you for joining us here at Self-Representing in Family Court, where we discuss all things strategy in family court. Join us next time. Until then, visit us at www.thedivorcesolutionist.com.